Why is a mortgage lender who's trying to foreclose on your home bound by stricter rules? More notices, more time, more process than a predatory used car lot that can repossess your car days after you miss a payment? The answer goes back almost 400 years, and it'll change how you see everything in this series about foreclosures. Another day, another solution. Let's talk dirt. So, before we answer that question, let's make sure we're all starting from the same place. In other words, what is a foreclosure? Foreclosure is the legal process by which a lender or another lien holder forces the sale of your real property to satisfy a debt you haven't paid. You borrowed money, you pledged your property as security, you stopped paying. The lender wants their money back. Simple enough, right? Now, think about that car lot for just a second. When you finance a car through a small used car dealer, they hold the lien on that vehicle. You stop paying, they have the right to repossess it. And in most cases, they can move pretty quickly. A few missed payments, maybe even one, and a repo crew shows up. Car's gone. So why can't a mortgage lender do the same thing with your house? Why all the notices? Why all the waiting periods? Why the courthouse postings and county filings and the structured timelines? The answer is not that lenders are more regulated. The answer is that your ownership interest in real property carries a different kind of legal weight than your interest in a car. And that distinction goes back 400 years. So in England, around the 1600s, courts of common law had a rule that wasn't much better than that of a car lot. If you borrowed money and pledged your land as security, and you missed your payment deadline, even by one day, the lender got the land. No questions asked. No notice, no cure period, no second chance. Doesn't sound very fair, does it? English courts of equity, what they called chancery courts, looked at that rule at one point and said, that's not right. A person's interest in their land has real value. It has long term value, permanent value. And before you can strip that ownership interest away, before you can permanently foreclose it, the law must give that person a meaningful opportunity to get it back. That principle has a name. It's called the equity of redemption, the right to redeem your property, to cure the default, to pay what you owe and keep what is yours. That is the answer to the question we opened with. The mortgage lender has to give you more notice, more time, more process, because your ownership interest in real property demands a meaningful opportunity to be protected before it can be taken from you. The car lot is selling you a vehicle. The lender is dealing with something the law treats as fundamentally different. Now, here's why I think it's important to spend time on this in episode 1. Every procedural requirement you're going to learn in this series, the 20-day notice, the posting at the courthouse, the mailing to your last known address, the filing in the county records, all the waiting periods, all of it flows from this one principle. The law requires those steps because equity of redemption demands that you get a real, meaningful opportunity to protect your interest before it's taken from you. Now, you can memorize every deadline and every statute in this series, and you should. The hows they matter enormously. Knowing the hows is what keeps you out of trouble. But here's the thing. If you also understand why this process works the way it does, you will be able to answer questions intuitively. Let me say that again. Understanding the whys allows anyone in the foreclosure arena, homeowner, investor, agent, attorney, to follow an intuitive process that will help them immensely in the future. Many questions can be answered before you ever look up the rule just by asking one question. Did this person get a real, meaningful opportunity to protect their interest in their land? That is the equity of redemption test. We're going to use it throughout this entire series. So now let's bring this into Texas law. Texas is what's called a non-judicial foreclosure state. Now, what does that mean? It means that in most cases, the lender does not have to go to court to foreclose on your property. That is very different from a lot of other states, such as Florida. And it is why Texas foreclosures can move fast, sometimes extremely fast. Here's the thing. Even without a court involved, Texas law still has to honor the equity of redemption principle. So instead of a judge overseeing the process, the Texas Property Code builds the protections directly into the statute. Mandatory notice periods, specific posting and filing requirements, a structured timeline that gives a borrower a real opportunity to respond. The vehicle is different from what a court provides. The principle is exactly the same. All right, so one more foundational piece before we get to the takeaway. In Texas, when you borrow money to buy real property, you sign a document called a deed of trust. And here's where it gets interesting. The deed of trust contains something called a power of sale clause. That clause is in your agreement. Your written consent that if you default, the lender has the authority to sell your property without going to court. That is what makes non-judicial foreclosures possible in Texas. But pay attention to this one. That power of sale clause does not eliminate the equity of redemption. It operates within that principle, not around it. The lender can sell your property, but only after the law's requirements have given you a real chance to stop it. Same principle, same answer every time. Now, real quick, if this kind of content is useful to you, go ahead and hit like and subscribe right now. We are in the process of building this entire library on Texas foreclosure law, from foundation all the way through post-sale consequences, and every episode builds on what came before. You don't want to miss the next one. All right, here's what I want you to take away from this episode. Remember the question we opened with? Why a mortgage lender is held to stricter rules than a predatory used car lot. Now you know the answer. It's not about the size of the lender. It's not about how much you borrowed. It's about the nature of your ownership interest in real property and what English courts decided 400 years ago that interest deserves. A real opportunity to be saved. That is the equity of redemption. It came from chancery courts in England and it crossed the Atlantic, and it lives inside the Texas Property Code right now in every notice period, every posting requirement, every structured deadline in this entire series. Keep that principle close. We are going to come back to it in every module, and you'll start to see it everywhere. In the next episode, we're going to cover the single most important distinction in Texas foreclosure law: judicial versus non-judicial foreclosure. Why Texas chose the non-judicial track, and what that means for how fast a lender can move. Where homestead property plays by a completely different set of rules. That's episode 2 of the foreclosure series. I'll put it in the link below. As I said before, if this video was informative, please make sure to like and subscribe below. I always like to remind viewers that these videos are not meant as legal advice. If you need help with a matter, you can contact us in the links below. As always, thanks for watching.